Good morning, everyone. For the record, I'm Matthew Cherry, TABC Senior Counsel. Today's meeting is going to cover the rules that were proposed at last month's commission meeting, and these proposals were published in the December 5th edition of the Texas Register. And as a reminder, today is not your only opportunity to provide comments. You may still provide written comments to the agency, and request that those be provided no later than January 4th of 2026. And so with that, I will get started with the first item. So this covers proposed amendments to Rule 45.130 relating to credit law and Rule 45.131 relating to cash law. So first up is the proposed amendments to 45.130 subsection B7C. And this amendment updates the list of applicable permits just to better track the controlling statute. And then the proposed amendment to 45.130C1 adds identification stamps to invoice information. And the proposed amendments to 45.130D1 and D4 add business days to the rule based on a prior comment that we received for the last rule review that we did for this chapter. And then the proposed amendments to 45.130 subsection H, 2, and 3 fix clerical errors and clarifies the process to be removed from the delinquent list and requires some approval by the agency. And then the proposed amendment to 45.131 subsection B7, subsection A, updates the list of applicable permits to better track the statute, just like we did in 45.130. And then lastly, there's some proposed amendments to 45.131 subsection C and C1, just to fix some clerical and grammar errors for better readability. And that covers the proposed amendments for item 1. And now I will open the floor for any comments. All right, I'm not hearing anything or seeing any hands raised, so I'm going to move on to item 2. And just as normal, once we get to the end, I'll open the floor again for comments on any of the items. So if you are still thinking about something you want to comment on for this first one, there'll be another opportunity at the very end. All right, next up is item 2. And this is going to cover proposed amendments to Rule 41.37 relating to destructions, 41.43 relating to sale after cancellation, expiration, or voluntary suspense of a license or permit, Rule 41.50 relating to general provisions, 41.52 relating to temporary memberships, 41.53 relating to pool systems, 41.65 relating to contract distilling arrangements and distillery alternating proprietorships, and then lastly, a proposed new rule 41.57 relating to the purchase of certain alcoholic beverages. So first up is the proposed amendment to 41.37 just removes a citation to a repealed statute. 41.43 subsection A removes the in bulk requirement for inventory sales. And 41.50, the amendment to subsection B just fixes a clerical error. In 41.52 subsection B1, the amendment clarifies the requirements for private club temporary membership cards. And then in 41.53 subsection E has been removed, and that subsection E is now being moved to the new 41.57 right below it. The text exactly the same. And then the proposed new rule 41.57 comes from that 41.53. And then lastly, we have this additional amendment to subsection E of 41.65. And all that does is it's a clarifying statement to make it clear that wholesalers and authorized carriers may pick up a product directly from a contract distiller's facility. So that covers all of the proposed amendments for item 2. And I will now open the floor for any comments. All right, I'm not hearing anything or seeing anyone's hand raised, so I'm going to move on to item 3. So item 3 covers proposed new rules 35.5 relating to prohibited sales of consumable hemp products to minors, as well as new 35.6 relating to mandatory age verification of consumable hemp product sales. TABC did previously adopt emergency rules relating to consumable hemp products. If these proposed rules are ultimately adopted, they will replace the emergency rules that we currently have. And these proposed rules are similar to the emergency rules, but with a couple of key changes. First, citations have been updated to account for the rules placement within Chapter 35. Second, the proposed rules will allow TABC to suspend a license or permit as a sanction in certain instances, whereas the emergency rules only provided for cancellation of a license or permit for any violation. These proposed rules provide a licensee or a permittee a defense to an enforcement action for failure to inspect proof of identification under new 35.6 if the ultimate consumer or recipient of the consumable hemp product is 40 years of age or older. And then lastly, the proposed rules restrict when a license or permit holder may apply for a new TABC license or permit if the holder's license or permit is canceled under these rules. So that covers the updates and the changes that we have, and I will now open the floor for any comments on this proposal.
Hey, Matthew. This is Mark Bordas. Can you hear me? On behalf of
Yes, sir. Good morning.
Texas Hemp Business Council, how are you this morning?
Doing well.
Well, we appreciate the Commission's prompt response to GA 56 and recognize the important refinements being made here from the initial emergency rules, but have some concerns over the difference in severity and treatment for infractions for sale to minors. For instance, in Chapter 106, for the first infraction of the sale to a minor for alcohol, it might be $150 to $1,000 fine or a 2-day suspension, whereas this proposal is calling for a 30-day suspension. So it seems like one set of regs is intent on keeping a business viable, while the other seems punitive. And the other thing that I would like to point out is there are, as far as for sale of hemp to minors, there are no implications for retail clerks willingly selling to underage consumers. It may be some type of commercial venture that they've entered in with their buddies, and they ought to have some skin in the game. That retailer ought not lose their alcohol license simply because they had a bad clerk wishing to sell to their friends.
Okay, thank you for those comments. They've been noted. Next, it looks like we have a hand up from Jeremy Sherman.
Yes, thank you, Mr. Cherry. Thanks for the opportunity to comment on the new Texas Alcohol Beverage Commission rules, 16 TAC 35.5 and 35.6, implementing Governor Abbott's executive order GA 56. I'm Jeremy Sherman, the co-founder of Bayou City Hemp Company, a Houston-based manufacturer and retailer of consumable hemp products. We manufacture hemp beverages as well. First and foremost, I want to thank Governor Abbott and commend TABC leadership and staff for swiftly adopting these emergency regulations to prohibit the sale of consumable hemp products to anyone under 21 and require ID verification at retail. These measures are a critical and necessary step towards protecting Texas youth. But I also want to emphasize the importance of extending the same protections to the online marketplace. In practice, minors can obtain consumable hemp products by ordering online, especially from out-of-state websites that may ship directly to Texas addresses without age verification at purchase or delivery. This online loophole threatens to undermine the intent of the executive order and the spirit of these rules if not addressed. At Bayou City Hemp Company, we take age verification very seriously. Through our operations at Eighth Wonder Brewery, one of the largest tap rooms in Houston, we have extensive experience complying with TABC requirements across both our alcohol and hemp beverage offerings. For online orders, we have voluntarily implemented something called Blue Check, an age verification tool integrated into our website that checks thousands of databases before a purchase is completed to ensure the customer is 21 years or older. This is an expensive tool that we voluntarily pay for as a responsible operator. Unfortunately, many online sellers ignore age verification protections entirely, creating an uneven playing field where responsible Texas businesses absorb real compliance costs while bad actors ship consumable hemp products with little oversight. We respectfully request that TABC, in coordination with DHSS, DPS, and local law enforcement, apply the same strong enforcement standards that exist for alcohol delivery to all online sales of consumable hemp products. In closing, we want to reiterate our support for TABC's new age verification rules and thank the Commission for taking proactive steps to protect minors. We respectfully urge you vigorously enforce these rules both in brick and mortar establishments and across online channels. By extending the same vigilance to online sellers as we do retail stores, we can ensure that the intent of Governor Abbott's executive order is fully realized. No minor should have access to consumable hemp products in Texas. Again, I want to thank you for your time, and had one clarifying question, if you could potentially answer that, or if not, at least put it on the record. It'd be fantastic. Is there any way I could get this is the distinction between 35.5 and 35.6. Could the agency provide a real world example of how these provisions would be enforced, including when each penalty applies and when they would be combined? So again, thank you for your time. I really
Thank you for the
appreciate it.
comments. Nope, I appreciate the comments. They've been noted. It looks like next up we have Nicole Holt.
Good morning, and thank you for the opportunity to provide comments on the proposed rules 16 TAC 35.5 and 35.6 regarding consumable hemp products. I'm Nicole Holt, CEO of Texans for Safe and Drug-Free Youth. Research shows that the most protective policy for our youth is one that keeps these products out of the marketplace. Just last month, the federal government changed language within the 2018 Farm Bill to clarify that these CHPs are illegal products. It is our recommendation that our governmental entities, including TABC, DSHS, DPS, and TDA, work together to align product definitions and rules to align with these federal rules. Regarding these rules that TABC has set forth, we support suspension and or cancellation of a license or permit when a licensee or permittee violates the law regarding this illegal sale of CHPs. Additionally, to align with the most current neurological and behavioral research, we urge the Commission to adopt 25 years of age as the minimum legal age for consumable hemp and THC products. This recommendation is based on substantial evidence that the human brain continues developing through the mid-20s and that early exposure to psychoactive substances can significantly increase risk for mental illness, addiction, and impaired cognition. There are also higher risks regarding impaired driving. We recommend that TABC require electronic identification scanning at the point of entry of retail premises to ensure accurate age verification and reduce underage access. We recommend that every consumable hemp product sold in Texas should be accompanied by a third-party certificate of analysis from an accredited laboratory. QR codes linking to these results should be required on product packaging, and these COAs, these certificate of analysis, must be verified with the THC content with a complete ingredient list and documentation of the absence of contaminants or adulterants. And then finally, we recommend supporting local compliance checks by establishing a cost recovery grant program that would assist local law enforcement and municipal partners in conducting compliance checks, underage stings, and inspections. This is a best practice already used in tobacco and alcohol enforcement programs. And in conclusion, I want to thank TABC for its work on this. The unregulated sale and marketing of intoxicating hemp products, particularly to minors, poses an escalating threat to the health and safety of Texas youth and on our roadways. TABC has the opportunity to set a national example by adopting rules that align with federal policy, promoting transparency and prioritizing prevention. And we appreciate all your hard work on this issue. Thank you.
Thank you. Next is Marcus Schwartz.
I'm on mute. Sorry. Uh, Marcus Schwartz here with the law firm of Bragg and Schwartz. Matthew, I have two questions on subsections E for the minor and F for the failure to ID, which relate to who is eligible for a permit after a cancellation were to occur. Um, the way I read this, or the way it's drafted, the following persons are not eligible to apply for and may not be issued any TABC issued license or permit for a period of 1 or 5 years, right? My question is for a chain-based location, right? And if they get one of these at one of their stores, would they then be prohibited from applying for renewals at their other stores if they're within a year, for instance?
I'm unable to answer that at the time, but that is absolutely something that we will take into consideration and just view that as a comment to look at that and potentially clarify. With
I
anyone.
appreciate it. I think you might want to look at an original permit,
Okay.
or if you want flexibility, may, right? Because then you may shut down others. At least give yourself some flexibility and not lock yourself in. The other clarification, and I think this is stylistic and a remnant of the past, but your use of corporation in those same subsections, I assume that's meant to apply to all entities, so to speak, and not just corporations.
Yes, I can say that that is correct. Currently, that term is used because that's just the way that most of the codes statutes actually read when it talks about the entities. But
I get it. I would just say stylistically, some of our more recent rules or your more recent rules you do use the word entity. So
Yeah.
for what that's worth.
Nope, I appreciate that. Thank you.
Thank you very much.
All right, I think next we have Andrea Steele.
Good morning. Thank you. Andrea Steele, attorney with the Banks Law Firm. I wanted to just push back on a comment that was just made regarding a request to change the definition to the language in the bill that was recently passed that would have changed the definition of hemp at the federal level. That bill does not go into effect for 365 days, and there was already a bill introduced, I believe, yesterday that would revert that definition back to something different or to something new. So I want to make sure that one thing Texas has been really good about with the hemp industry has been maintaining alignment with the federal standards. And so I would just suggest that no changes be made to any definitions that have a federal definition already. That's it. Thank you.
Thank you for the comment. I still see a hand raised from Jeremy Sherman. Do you mean to have your hand raised, or have you finished your comments?
No, I apologize. I'll take it
Oh,
down.
nope, not a problem at all. And then Mark Bordis, your hand is still raised as well. Do you have an additional comment to make?
Yes, I do. Thanks, Matthew.
All right.
I just thought it was important to highlight that the definition of consumable hemp product under section 35.5A1, that the proposed rules appropriately cross-reference DISH's definition of consumable hemp product, and to avoid confusion and promote interagency consistency as well as marketplace confusion, we recommend that the TABC track the statutory and regulatory language more closely in the rule text by clarifying that a covered CHP, consumable hemp product, is again just aligns with DISH's definition. I won't go into reading that definition. I'm sure you're aware of it, but I will submit it in my written comments.
Understood. Thank you. Appreciate the comment. All right, next we have Anthony Ibarcina. I'm sorry if I'm pronouncing that incorrectly.
Yeah, that's correct. I just want to second what Andrea said about the federal definitions, keeping them and not just creating new definitions that need to be put in place if there's already ones.
Thank you for the comment.
Thank you.
All right, I'm not seeing any hands raised. Is there anyone else that would like to provide any comments on item number 3 or items number 1 or 2 that we covered at the beginning of the meeting?
I would like to say something, but I'm not seeing how to raise my hand.
Not a problem. You could just continue speaking. If you would just state your name so we know who that is, that would be helpful. Thank you.
My name is Jokubas Žiburkus, and I'm representing myself and also our company called Uniwise. And I wanted to, first of all, thank your commission with addressing this very timely issue of regulating hemp. And I wanted to maybe have a look ahead that from regulators' perspective, I think some of the most central challenges are highly heterogeneous products that are often marketed under overlapping labels such as hemp or THC, Delta 9 or CBD, and they have widely varying strength and cannabinoid profiles. So I think looking forward, this fragmented market of thousands of outlets right now, it's very difficult to supervise, but there is a need for an effective oversight moving forward. There was already a mention of certificates of analysis, which they actually already exist lawfully. Every hemp product on sale should have a certificate of analysis. However, it was correctly noted that those COAs, the certificates of analysis, are not being systematically aggregated, inspected, cross-referenced to actually testing facilities, and normalized to some sort of a system or taxonomy. And so what I wanted to introduce to the state of Texas is a system that is a patented software implemented taxonomy and analytics platform that is called Uniwise, that was specifically created to regulate all of the diverse spectrum of THC and cannabinoid hemp and in general cannabis products. What is very important after the institutionalization of checking off the IDs and the age limits, it is very important that the consumers are facing smart labels and that there's a public trust in the products that are being sold. And so what we created with Uniwise is a system for essentially regulating these thousands of locations and products that is based on what is in the final product and on the actual ingredients, cannabinoids and other ingredients in the final product that gives you relative strength and potency identification for the regulators, but also for consumers. It identifies the psychoactive cannabinoids, those that are intoxicating and those that are not, and also distinguishing between naturally occurring cannabinoids, such as cannabidiol, CBD, and Delta 9 THC, and those that have synthetic origin, such as Delta 8 THC and Delta 10 THC. So I hope that looking into the future and future discussions, maybe this is running ahead of where current regulations are. We hope that the commission is open to actually look into smart regulatory systems such as Uniwise. Thank you very much once again for doing this work.
Thank you for the comment. All right, is there anyone else that would like to provide any comments on items 1 through 3? Yes, it looks like Christine Scruggs.
Hey, I don't have anything prepared, but I did look over the rules and I listened to the November 18th meeting yesterday. I had a son who was an adult when he started using THC and had mental health consequences because of it. And I just want to say that I would agree. Well, I don't agree with it being safe for 21 and up, first of all, but I would like to I'll probably write this also, but I would like to insist that you guys make the most, I guess you would call it harsh punishment for selling to minors or for not checking ID. I see that they could get a 5-year or 1-year suspension. I just would like that to be increased, and I also would like. I know that they talked yesterday, or in the video, they talked about one strike and you're out. What people don't realize is that commonly when young people, not super commonly, but it is not uncommon that people who use for the first or second time develop. There have been multiple cases of long-term mental health issues from a one-time use. That's what people do not understand. And when we say, oh, it's okay, you're going to get a 30-day penalty, and someone's life has been permanently altered, I think it's really important that you do what is best for public safety. And I'll write some more comments, but I just wanted to share that today.
Thank you for the comments. All right, I also see a hand raised again from Anthony Ibarcina. Do you have an additional comment that you would like to provide?
Yes, I just wanted to make sure that when these analysis certificates are required, that we could be using state level facilities and not having to use analysis outside of the state. That way, there's quicker turnaround times, and we just have facilities within our state that are doing the analysis.
All right, noted. Thank you for the comment. All right, I see a new hand raised. I'm sorry, it doesn't have a name. It just says ECL ECL testing.
Yes, my name is Matthew Madison, and I'm with ECL Testing. I just wanted to respond to the previous comment that was just mentioned about testing being done by state level facilities. This isn't exactly pertinent to the regulations that TABC is proposing. I think DISHES is going to be handling testing. But as someone who's owned and operated a laboratory in the cannabis industry for over 15 years now, I would just say that in every market, and I am a native Texan, but I have had businesses outside of Texas as well in medical and recreational markets. And testing has always been done on a third-party basis. I think that's one of the things that people find most unusual about the fact that we have a medical program where dispensaries can test in-house. It lacks a lot of credibility. In fact, I've literally had some of our major clients in the past say, hey, we're the ones that pay your bills. We're your major client. You have to do what we want. And that puts a lot of pressure on a laboratory. I've never succumbed to that pressure, but I know that that is put on laboratories by major clients, and that if you had an in-house laboratory, that laboratory would almost have to be serving the entity that it's working for. Otherwise, they wouldn't make any money. So that would be a huge conflict of interest. Third-party analysis is what allows people to have a quality chain of trust. And there are accreditations that make sure that you can trust the laboratory testing. For instance, ISO 17025 is an international accreditation that standardizes the way reporting is done and the way laboratories run their facilities and their quality systems. Now, there's also DEA registrations. I have the DEA coming out to our lab on Monday, actually. But these programs, the licensing is already regulated, and this is consistent with the way other states operate. And on the federal level, I would say, just since we're talking about testing and cannabinoids, the USDA requires that total THC be the metric. However, the DEA and the current Code of Federal Regulations do not require that. They only require Delta 9. So there is a conflict there. I know there's a proposed change for the Farm Bill in 2026 that may include total THC, but that's something to consider as well, because there is an inconsistency there. And even though as an ISO accredited lab, we do have to report those numbers, that's not the enforcement standard. It's been reviewed multiple times already over the past, basically the past 7 years since the Farm Bill was put in action in 2018. And more than once, it's been reviewed, and they have not made a stance on the federal level other than the USDA regarding total THC versus just Delta 9 at the 0.3 level. which makes a huge difference in the way the products would be regulated and considered consumable hemp products. So I just wanted to mention that there's no reason for state facilities who actually have a long turnaround time. I looked at the website of a state facility in Houston, and I believe their turnaround time for potency was about 45 to 55 days, whereas we currently turn around results in about 48 hours. And so that's an unmatched turnaround time where the private sector definitely will handle things much better than going through the government for something like that. So I just want to make sure that's on record, and I will be submitting um, written comments as well. Thank you.
Thank you for your comments. Christine Scruggs?
Sorry, I didn't mean to keep my hand raised.
Oh, not a problem. Thank you. All right. Is there anyone else that would like to provide a verbal comment on items 1, 2, or 3?
Matthew, Amy Harrison with Amy Harrison Consulting. Thank you for the opportunity. I'd just like to echo Mr. Bordas' comments about servers having skin in the game. I think in alcohol, you've seen a very high compliance rate. And I believe that's a model that has proven to be effective. And I would highly recommend that that be considered and actually putting some regulation down to the servers level to ensure that we provide the safest environment and follow what alcohol has shown to be effective. Thank you.
Thank you for the comment. All right. Is there anyone else that would like to provide any comments on items 1, 2, or 3? Okay. The other thing, there is a written question from Kimberly Frost. It's a question on 35.5 subsection E2 and the similar provision in 35.6, asking who is a person with an interest in the license or permit. 3 and 4 only apply to 50% owners, and 2 sounds like it includes any owner, even a minority owner. I will note that down as a comment, and we will take a look at that when reviewing for adoption before next month's commission meeting. So thank you. All right. Would anyone else like to provide any comments on items 1, 2, or 3? I'm not seeing any hands raised. This is going to conclude the meeting, but I'd like to remind everybody, today was not your only opportunity to provide any comments on the proposed rules that we went over today. You still can provide written comments. We request that those be provided no later than 5 p.m. Central Time, January 4th, 2026. Those written comments may be submitted to the agency via email to rules@tabc.texas.gov or via regular mail addressed to Office of the General Counsel, Texas Alcoholic Beverage Commission at P.O. Box 13127 in Austin, Texas, zip code 78711. And thank you all for your time. This will conclude today's public hearing.